I am Nick Hughes. I'm the founder and CEO of Founders Live. Joining you today, I'm back in the United States. Finally, I'm back in Seattle, Washington. Excited for this. And I want to introduce and bring up Alberto Mujica from Startup or Scale Up Legal. Alberto, welcome and join us in the conversation.
Thank you, Nick, and thank you to Founders Live. I love Founders Live, and before joining you guys, I was a fan. I love what you guys do with the ecosystem, and I'm super excited to talk about, startup law in general, corporate law. It tends to be a dry subject, but I'll try to make it as exciting as possible. And I think it is an exciting topic. It's very cool stuff. And I thank you all for joining us. And Luis and Nick, thank you guys for putting this together. So as Nick mentioned, we don't want to follow a hard agenda or anything like that. You guys are welcome to ask questions. I'll do my best to answer. And but I do have a presentation sort of to guide us through some topics that may be important and that you may be curious about, as I presume most of you are founders or involved in the startup ecosystem. And so we'll have that presentation to guide us, but feel free to stop me, raise your hand, put up a question on the chat, and between Nick and I, we'll do our best to answer everything we can. So so if you can, get on mute, that'd be great. So I guess I'll start with the presentation.
Perfect. Yes. And as Alberto is bringing that up, I just want to remind everyone for a few things. Number one is we have the chat box there. Feel free to share, say hi. Don't blast too much, but if you want to post, maybe even share a LinkedIn link or whatnot, just let people know what's going on. Feel free to do that. If you have questions, you can post them in the chat, or you can raise your hand and then we will get to those questions. We're going to save questions for a little later in the conversation. So we'll just note that and go from there. But thank you for being here, everyone. And we're excited.
All right, I guess that's my cue. So with that, I'm going to start by saying a little bit about myself. Before becoming an attorney, I was a systems engineer. I was a data scientist. I had my own startup. And in general, my entire career has been working with, for, or in startups. I find it extremely exciting to engage in the idea of going out and changing the world and making a profit in the process, and everything that is involved, from the technology side, from the data side, and of course from the legal side, to make sure that ultimately, I mean, the idea of putting together a business is, coming up with a great idea, somehow keeping competitors out, minimizing your risks, attracting investment, and attracting customers. So with that, I do, as a lawyer, have to say that nothing I'm about to say is legal advice. But if you have any questions, you can reach out to us and we'll be happy to answer, make actual.
I'm sorry. I just want to step in here and remind everyone, please make sure that you're on mute as you come in here. We do have a guest speaker here, and let's just respect that. Thank you.
So yeah, ultimately, the point is that none of this is legal advice, even though we'll try to answer your questions and help you through this. So my specialty is startup law, and that includes a lot of intellectual property and corporate law. because as a startup, we focus on creating a business. And the first step in creating a business is setting up an entity. So what's the whole point? Why do we create entities? Entities are these corporate fictions created, these legal fictions created by the state in order to encourage business, encourage risk-taking by limiting your liability. So the whole point of creating an entity is to limit your liability. If you don't set up an entity, you're putting all of your personal assets at risk. So that's the first reason to create an entity. Another reason is to protect your assets, which stems from the idea of limiting your liability. So, for example, if you go into business and there's a lawsuit and you don't have an entity, if you were functioning as a sole proprietorship or just a partnership, your car, your home, everything become fair game for the entity or person that's suing you. When you have a corporation or an LLC, or in other words, an entity for your business, then you've limited your liability to what you've put into the entity, your capitalization into the entity, and you've protected the rest of the assets that you have, your personal assets. So another thing that entities give you is the ability to reduce your tax liability. When you create an entity, you're able to offset or reduce your tax liability because entities are taxed on their profits and not necessarily on their revenue. So you're able to discount from your revenue the costs of doing business. And finally, the idea that the point of creating an entity is also to attract investment. So if you have an idea and to raise capital so that you can move your business forward, an entity gives you that structure so that you can sell portions of your future revenue or structure different kinds of deals in order to return some of that revenue or profits to your investors, which is something that you would be unable to do without an entity. So the next question is, what type of entity makes sense for your kind of startup? There's no one size fits all, and that's where, talking to an attorney about what your intentions are and what you're trying to do helps you determine what the right kind of entity is for you. So the easiest and fairly new type of entity to have is an LLC. An LLC stands for a limited liability company, and it has a lot of advantages, in particular the fact that it has passed through taxing. So, for example, corporations, they get taxed at the corporate level, and then the profits that are shared among the owners or the shareholders also gets taxed. With an LLC, that doesn't happen. The company itself doesn't get taxed, but the owners in their distributions get taxed at that level. What are some of the issues with LLCs? Well, they can't go public. You can't list an LLC on the stock market. You have members, not shareholders, which changes the details of what rights they have. And in general, investors are not interested in, prefer not to invest in LLCs because of the share structure. when you have an LLC, you don't have shareholders, you have members. So the next type of entity is called a corporation, but in this particular case, I'm going to talk about S corps, which also have some of the same advantages as LLCs when it comes to taxes. You get passed through taxation, but then although you have shareholders, you have all of the other benefits of corporations, you do have limitations, right? You have a limited, you can't have preferred stock and common stock. You can only have common stock. There's a limit to the number of shareholders. There's a limit to the type of shareholders. And because of this reason, institutional investors also do not prefer S corporations. Finally, there's C corporations, which is the most common used when you're trying to raise capital. You can have classes of shares. You can have an unlimited number of shareholders. You're able to go public, list your company in the stock market. It is, and therefore it's attractive to investors because they're looking for an exit, whether it's via IPO or acquisition or something like that. And the C Corp gives them all of these exit options. However, there is one problem with C Corps is that they do get double taxed. They get taxed at the corporate level, and then at the shareholder level, the shareholder has to pay taxes as well. So that's concerning the types of entities. Now, the other concern about entities is that you can have them in different jurisdictions. I'm sure all of you have seen, these large corporations, they're always in Delaware. Some of them are in Nevada is another common jurisdiction. Some of them are in Florida. I happen to be a Florida attorney, and I think Florida is right now a hotbed for startups, like California was at some point, and some of the benefits of Florida corporate law is that it has very low cost. It has very low taxes. You're unlikely to need a registered agent. It has your LLC, for example, could be managed by another LLC, and therefore you're gonna have an additional layer of privacy. But in general, investors, especially large institutional investors, they're not going to prefer Florida. They're likely to prefer Delaware, which is why you see so many corporations incorporated in Delaware. And as an example, I went to Berkeley Law, and I also went to Nova Southeastern University, and I also went to the University of Barcelona to study law. So I have three law degrees. And one thing that caught my attention about how corporate law was taught in Berkeley versus the other places where I've studied corporate law is that Berkeley focused, although it was in California, Berkeley, California. The law that we studied at Berkeley was all about Delaware. Why? Delaware has become the place where you have the most expert judges, corporate lawyers, and the most elaborate and complete corporate law. In fact, Delaware's law, corporate law is used as a model throughout the country. In fact, Florida law mirrors Delaware law. It has dedicated corporate courts that only deal with corporate matters. It also has low taxes, which is probably what made it historically attractive to corporations and what then made Delaware expert in corporate law. And it is attractive to investors. Why? Because investors have typically invested in several companies, at least several companies, if not many companies. And they're familiar with working with Delaware. There won't be any surprises, as opposed to if you incorporate in Montana or in some other jurisdiction. So Delaware is attractive to investors. Of course, it's going to be a little more expensive than in other jurisdictions, and you're going to need a registered agent. The rest of the U.S. states, they vary wildly, from super high taxed jurisdictions like New York, New Jersey, California, to very low tax, super high privacy, different court rules. So I won't go into all of them, but just keep in mind that there are other jurisdictions, and some have some advantages and some have some great disadvantages. So this is a natural spot for me to pause and ask if you have any questions. Nick, did you see anything in the chat that maybe
there's one in here I want to pull out because it's relevant right to what you were talking about. How difficult is it to convert from an LLC to a C corp, maybe after a significant amount of funding or whatnot, but speak to maybe that starting with an LLC and then transitioning to another entity.
It really is. It's not that difficult. Of course, it depends on every corporation is different, and one of the advantages of LLCs is that they can be extremely flexible. So the operating agreement of an LLC really gives you a lot of flexibility. So some of these operating agreements are 100 pages long, and some of these operating agreements are 2 pages long. So depending on the complexity of the LLC, for some very large companies are LLCs, and it really depends on what type of LLC, what are the operating agreement, what are the rules in the operating agreement, and how and what you want to convert into, and how do you want to go through that conversion. Does every member of the LLC get an equal share of stock? It really depends on how you've structured your operating agreement for the LLC. But also, in the end, are you going from an LLC in Florida to a C corp in Florida, or are you going from an LLC in California to a C corp in Delaware? All of these things matter, but in reality, it's not that difficult for a simple LLC to C corp conversion, but it can be extremely complex otherwise. Presuming that for a startup that starts as an LLC and quickly, before having a large number of members or shareholders, converts to a C corp, it should be a fairly simple process. So I hope I answered that. Any additional questions on this?
Yeah, well, we had actually, I'll open the opportunity for Mark to, if you would like to elaborate, if there was any other questions, let us know. If not, then we can move on. But Mark in the room had answered that question around that. What I can just share on this is this actually, it's that's how Founders Live actually, when we originally started, I just got an LLC just to get things moving, and we did transition to a C corp. It's not difficult. Just got to take a few steps there, and a little bit of paperwork, and all of that. Yes. There is another question. We'll jump in here in terms of maybe talk a little bit. How crucial is it when you look at a banking partner and choosing a bank? I'm not sure if you have experience in this direction of suggesting the startups what path they want to take on that, but maybe just talk a little bit about what would be smart when founders getting something going. I'll even structure the question this way. I mean, let's even go to like, why should you have a bank, right? Like, you know, the legal entity needs to actually have a financial institution, specified bank. Do you have any suggestions when you see companies forming, especially in, you know, maybe we can talk about this later, but, you know, kind of foreign entities establishing in the United States? They have very few thoughts and ideas around what bank should they choose? Do you have any thoughts around that?
Yeah. So when it comes to banking, I mean, it really is. It's a broad question, right? There's you know, we just saw Silicon Valley Bank and a few other banks collapse, so that it's never a surefire thing. But I would say, if you're going to look for capital, and your intention is raising money, then I would say think of a bank like Silicon Valley Bank, a bank that's friendly to startups, that is going to be willing to give you a loan on receivables or something like that. And those relationships are important to develop. So if capital is important, or venture capital, you're better off going with a bank like Silicon Valley Bank, or a bank that's friendly to startups. Otherwise, if your intent is to open up a very successful bakery, for example, then a bank that has a lot of experience with, for example, SBA loans or something like that might be important. But I mean, it is a broad question, and it runs the gambit. There's all sorts of banks. Sometimes your local community bank will give you better treatment than one of these gigantic banks, including Silicon Valley or Silicon Valley Bank or Bank of America or one of these bigger banks. So it really depends on what you're looking for and what you can get. Because if you've had a banking relationship with one of your community banks, and your banker knows you, and you know the manager, and you have a good relationship with them, you might be better off going with them. But it varies. It really does vary, and you should look at what options you have before deciding on a bank blindly. So,
got it. Jay Park has a hand up. So Jay, feel free to jump in and say hi and ask a question.
Thank you, Nick. I have two questions. One is, when we negotiate contracts between two companies and we have two different jurisdictions, how firm or how flexible should I be to take their jurisdiction, or should we vote for my Delaware or whatever jurisdiction that we choose to? The second question is, when you deal with international contracts, there's a international, the country jurisdiction as well. Do you have any recommendations for international or different countries for the purposes too?
I'm sorry, Jay. I tried to keep track of the question, but I lost it. I'm going to say the jurisdiction of the bank is not as important as the jurisdiction in which you are establishing your corporation. Most banks are national banks, unless you're going with.
Yeah, my question was not about the bank; it's about the corporation.
Well, could you repeat the question? Maybe summarize it real quick.
Sure. So let's say my company has a Delaware as my jurisdiction, and my different partners or different companies, their jurisdiction is, let's say, New York City. How firm should I be to say, okay, we want the contract to be Delaware as the jurisdictions, or take their jurisdiction, and we take their jurisdiction? Those are my questions.
Great question, Jay. Now I understand your question better. So I would say one way or another. If your jurisdiction, if your entity is a Delaware entity, you can be brought to court in Delaware, because that's where you incorporated. Wherever you incorporate, that's where your corporate home is, and you will always be able to be taken to court there. You have to, depending on what your legal relationship is. If you have an attorney that works with you, or your in-house counsel, then what you want to do is always try to do to have the jurisdiction over your contracts be your jurisdiction. Why? Because it'll cost you less to go to court. It'll cost you less to use a licensed attorney from your jurisdiction. And that's really, and there are friendlier, jurisdictions that are friendlier for corporations. For example, Delaware is one. Florida is also a corporation-friendly jurisdiction. Some other jurisdictions are not as friendly to corporations, like even California or New York, and you'll see rarely enterprises incorporate in those two, but it does happen. So I guess to answer your question more directly, the two factors that I would consider when it comes to where you want to, how you want to, what jurisdiction you want your contract to be in, I would try to keep it home. Always try to keep it where you are, where your legal counsel is, so that it will be less expensive and you'll be able to use better counsel. If you've done your incorporation properly, then you will already be in a jurisdiction that should be friendly to corporations, like Florida or Delaware. And that's probably what you're looking for. So I would say, yeah, Delaware is a great place to make by default your contracts be. But there's a few other factors, especially when it comes to if you're doing some very highly regulated business, like something where HIPAA applies, or some other detailed state regulated business. Let's say, for example, the legal business is regulated state by state. So my contracts have to be in Florida because that's where I'm licensed. I hope I answered that.
Very good. Well, Alberto, we have an interesting thought and question that I think is a good segue for you to address and talk a little bit about foreign startups and companies that might be looking at the United States. So the mention here is that, this seems to be a pretty USA, or, why were like other founders invited to this when you're talking about LLCs and things that are US based, focused, when, founders and entrepreneurs from other parts of the world might not be familiar with, these sort of things. Well, I mean, that's kind of part of the point here. And Alberto, could you describe a little bit of your service? And when you talk with startups and founders from different parts of the world that are looking to start doing business in the United States and looking to incorporate, maybe what perspective do you share with them, or some thoughts to think about in that realm?
Well, this is US focused because ultimately, I mean, there are great international markets like China, India, Europe, South America, the US. There are great markets out there, but the US continues to be a really strong market for both marketing to consumers and also for raising capital. And what I help in general to do with corporations that already exist, or businesses outside of the US, that want to enter the US market is precisely that. Structure the corporate relationship between the foreign entity and the soon to be domestic entity to minimize tax liability, to allocate assets appropriately, to allocate profits appropriately, for example, immigration, business level immigration for executives and so on that need to come to the US to market, to seek investment. So that's where that comes in. You know, at the international level, yes, this is US focused, and I am a US attorney. So the idea is to help you guys come to the US if it's what you seek to do, or if you see that there's a market either for investment or for your business in general here in the US. So I see Mark raised his hand.
Yeah, let's go with Mark. Mark, feel free to unmute and jump in here, say hi.
Sure.
And
Thanks so much. Yeah, I just actually went through a process of setting up a Delaware C Corp. And then there's some add-ons in terms of the share plan for employees, some IP licensing. And I consider myself a relatively experienced and well-traveled business person, but going through the legal process, there were a few surprises for me. And I would like to hear you put your advisor hat on, and you're talking to some potential founders or founders here, and give them some advice in terms of negotiating legal fees in advance. And here's my particular concern. I was quoted an amount, and there were some surprises. And even after the surprises, when we agreed to say, okay, we're going to get it done for under X amount, came back almost 2x, with the attorney saying, hey, I was surprised by this as well, but I had to have my colleague do this work, and it was extra. Now, in the world that I've lived in, when you provide a quote for something, you're pretty much bound by that quote. And we worked it all out. But I would like you, if you could put your advisor hat on, what advice would you give to people like in our situation to negotiating legal fees, or at least getting a handle on what it's going to be?
No, not to, we function different ways, right? Number one, when we say a flat fee quote, we mean a flat fee quote. If they're deviating from that without very strong justification, because I mean, creating a Delaware Corp is something for an attorney should be something trivial, well, at least for an experienced attorney. So if they're deviating from that without giving you a very strong justification, I would reconsider dealing with them, because that's another thing. I mean, not all attorneys are not fungible, they're not the same. It is very personal work, and when I tell a client that this is what it's going to cost, and I quote him a flat fee, even if in the end some surprise comes up. I mean, the thing is, I won't quote a flat fee unless I'm pretty sure I know exactly what I'm quoting and how much work it's gonna take. And if there is a surprise and I end up losing money on that, well, that's my responsibility, and I should eat that cost. So if they're not behaving that way, that may be I would reconsider. But most most attorneys will do a Delaware corporation without you know.
Okay, and I don't want to I don't want to take up too much time on this question, but I would just say it was more than just the corp. It was also setting up the employee share plan and so on, some IP documents. But we had agreed to this is what it was going to be, and so what I'm hearing you say is that you can negotiate a fixed rate fee for a package of service. And yeah, there may be some surprises, but but typically there are attorneys out there like yourself that are willing to go ahead and say, hey, I'm going to take a haircut on this and deliver the service that I said for the price. This is not like an industry thing where, because I mean, I really felt kind of exposed in this that, once you start going down the path with a given attorney, it's hard to back out, right? And I chalked up to a lesson learned, but I also appreciate your advice there that you can negotiate that. That's what I'm hearing you say.
Yeah, and I mean, most importantly, I think in any business situation, a contract is a contract, and I mean your word is your word, and if I tell you it's going to cost you this, and unless something really exceptional occurs, I should stick to it, even if I break even or lose a little money, because that's the commitment that you make. So,
thank you.
But anyways,
cheers.
Yeah, no problem, Mark. And thank you all for your questions. I do want to move forward before we run out of time, and talk a little bit about intellectual property. So I'll proceed with that, and that way there'll be some time for you to ask questions about the IP portion. So, well, ultimately, like I mentioned before, you want to create a company, you want to develop a product, you want to exclude competition, you want to raise capital. One of the most important ways to do that is by protecting your IP, right? What happens with intellectual property rights? You get an enforceable, meaning that the FBI will go and stop them, the Federal Trade Commission will go and stop them from using your intellectual property. So it's an enforceable and exclusive right, and it's very strong and it's very important, and it's one of the most important things that make the U.S. A very interesting market to work in, because these rights are enforced and enforced strongly. Another thing about IP is that IP is very scalable. So copyrights, trademarks, patents, these are rights that scale very well. You're able to with you write a song, you write a book, you make a movie, you make it only once, and then you can sell an unlimited number of times. So it scales very well. So IP is one of the best, intellectual property assets are one of the best kinds of assets that you can have, especially in Delaware. Intellectual property revenue is taxed very lightly in general. So you're able to, in addition to that, you're able to move your assets very easily. One example is if you get a patent, you can create a corporation in Grand Cayman, sell your patent to them. They can license a patent to you, and these are both owned by you. And the profits that you make can be assigned to that Caimani corporation, where you'll have pretty much zero taxes. Not pretty much, it's actually zero taxes. So that level of flexibility is something that you can get with IP assets. And finally, the whole point of this exclusivity, enforceable exclusivity, is that you can keep your competitors out, right? You can stop your competitors from using your invention, from using your brand, and from using your creation in the case of copyright assets. So how do you protect them? Everybody has heard of patents, trademarks, and copyrights. So we're going to go into a little bit about these so you understand the differences. A patent protects inventions. The protection is a monopoly over that invention for 20 years. It's the hardest type of intellectual property protection you can get. It's the most expensive as well. But the kind of protection that you get is so strong because if you have an invention and you didn't copy from anybody, this is your invention, you came up with it and you got a patent for it. And let's say someone else comes up with the same invention without knowing about your invention, without copying your invention, it doesn't matter. You got the patent, you have exclusive right to it, even if someone else developed it independently. It's the strongest kind of protection, but it's the shortest. So, copyrights. Copyrights are works of authorship, like I mentioned before, books, movies, software. It's very long protection. It's life of the author plus 70 years. In general, there's other exceptions and so on, but I won't go into those details. And something that most people don't know is that you have a copyright of everything you do right now. I haven't registered the copyright of this presentation, but that doesn't matter. I already have a copyright. At the moment that you fix something onto a medium, you have a copyright over that. However, it's in your best interest to register that copyright, especially if it's a valuable asset. But you don't need to register. Thing about copyrights, it's longer protection, but it is flimsier protection. It's not as strong because just like I came up with this presentation or this book, someone else can come up with another book that's very similar ideas. Someone else can come up with a mouse called something like Mickey. And as long as it wasn't copied from Disney's Mickey Mouse, they have a right to have it. It's long protection, but it's the kind of protection that's easier to overcome. So finally, we're going to talk about trademarks. Trademarks, the point of trademarks and where trademark rights emanate from is from their use in commerce. So you have a product and you've branded it and you've advertised it as yours. The whole idea is to stop other people from using your marketing and taking advantage of your marketing for the product that you've invested in already. There is no limit of time for trademarks. As long as you use it in commerce, it's yours to keep. The rights emerge from their use. And it's very long protection, but not only is it easy to overcome, you can actually lose your rights to a trademark if your name becomes generic. For example, when it comes to copiers, Xerox. If somebody, the Band-Aids, these are brands that, because they no longer identified a particular producer of a product, the owner of the trademark lost the rights to the trademark, because the whole purpose of a trademark is that it identify a particular source of products or services. So this is a broad, quick overview on the three major forms of intellectual property. There are others like trade dress, design patents, trade secrets. But these are the main ones, and these are what all these other derivative forms of intellectual property all stem from these three. So where am I getting to with all of this? To get into business, to be successful in business, you want to create an entity, limit your liability, reduce your taxes, protect your assets. Protect your IP assets. So you have an asset, which is typically startups, their assets are typically intellectual property assets. With the protection of your IP assets, you can stop competitors from getting into your business. And ultimately, by limiting your liability, protecting your assets, protecting your IP assets, which are scalable, and stopping competitors with that IP protection, you ultimately go out and attract investors. So best of luck to all of you. Let's see if you have any additional questions.
Yeah, Alberto, thank you. We actually have a aligned question around the trademarks and patents and all that. It's actually, so Jamie Chavez, I hope I'm pronouncing that correctly, but has mentioned and asked around, startups that are looking internationally, what are your recommendations to the extent of trademarks, patents, and et cetera, that should be filed to begin conversations when you are looking to expand internationally? It could get costly, keeping mindful of that. So are NDAs just enough, or what should startups look for when they are expanding internationally? And this is something that, Founders Live and myself are obviously interested in as well. We have our own perspectives on this, but what do you suggest when early stage startups have ambitions to expand quite far internationally, but want to consider the IP protection?
When it comes to patents, if you already have a patent here over something, then people abroad already have access to that. Because once in exchange for the United States Patent and Trademark Office gives you the 20-year monopoly on your invention in exchange for your publication of it, right? The idea that, and this is written into the Constitution, the idea is that we'll give you a monopoly for 20 years, but you show us how you did it so that humanity can move forward, right? So the point is, when it comes to patents, if you're going out of the country, these they already know it. The only thing that you can take advantage of is international treaties that will give you an effective date, backdating to your effective date in the United States. But patent protection is jurisdiction by jurisdiction. It's very painful. Some jurisdictions like the EU give you some advantages in bundling for a patent for several jurisdictions. But in general, it's a jurisdiction by jurisdiction, and some countries are signatories to these treaties and some are not. When it comes to copyright, in general, copyright in most jurisdictions is the same as it is here. Once it's yours, you set it onto a medium, it's yours. And so you really don't need to do much. But like in every jurisdiction, there are advantages to registering your copyright. And if you're targeting a particular market, both for your patent or for your copyright, it's in your best interest to register that copyright in that jurisdiction and to extend your patent to that jurisdiction as well. When it comes to trademarks, it's a little easier, I think. because the rights for trademarks emanate from your use in their use in commerce. And so if you're, for example, Nick, if you're doing your Founders Live events across the globe, you do get some protection, but there are as well treaties where if you go jurisdiction by jurisdiction, particularly in jurisdictions where it matters to you, or you find that someone is trying to infringe your trademark, then you do want to go register there. And depending on on whether this jurisdiction is a signatory to a treaty, then they'll give you an effective date going back to the time that you got your trademark here. So the summary answer to that is it's jurisdiction by jurisdiction, but there are ways, and I think and it really depends on the jurisdiction, whether they're signatories and how you can take advantage of that. But generally speaking, most jurisdictions have similar laws for intellectual property. What they lack, which is one of the advantages of doing business in the United States, what they lack is proper enforcement of those rights. So that's a whole other.
Yeah. And hey, we're coming down to the end, everyone. This has been really, really great, very educational and helpful. Let's end with that, which is in maybe a succinct manner. What would you suggest the steps would be if there is awareness that they might be infringed upon? So, and let's acknowledge that startup doesn't have a patent. Okay. They do have copyright, and just they've been in commerce for, let's say, 2 or 3 years or whatever. Point is, when there is awareness now that there might be an infringement, what is the steps to take to do that? Like, what would be the right first couple steps if they want to actually put a stop, as you mentioned, put a stop to the competitors?
First, if and we're talking about infringement on what, copyright or trademark?
Yeah, I would say
Okay.
copyright. That's probably going to be the more common versus, I think
Okay.
it might be a much larger conversation, but just simply like, hey, they're using our brand name in this other country, or they're doing something where it's like, what needs to happen?
If it's your brand, then we're talking about trademarks. And if that's the case, then the first step is putting together a cease and desist, right? And if you haven't registered a trademark there, register the trademark. So then you have a leg to stand on, and then get a cease and desist letter to them to see if they voluntarily stop doing it. Because that's always easier, especially in some countries where enforcement is lacking. A cease and desist letter might be your best bet. Countries like the United States and Europe and so on, where enforcement is strong, then you can realistically threaten with court and law enforcement and so on. But yeah, the first step would be, get an attorney, write a cease and desist letter, get it delivered, and make it clear to them that you've noticed the infringement and that you want it to stop. So that would be the first step. Then there's plenty of other steps, right? If they don't stop with the cease and desist. And here in the US, it would involve everything. I mean, all the way up to the Supreme Court, if necessary. The Federal Trade Commission, everybody can get involved, and they do in order to protect a trademark.
Very good. Well, Alberto, this has been amazing. Thank you for your time here. Absolutely. Share a few links, or if people want more information, you know, what would you suggest the steps they take?
Well, I mean, go to our website, scaleup.legal, or I have the information up for my contact information. Reach out to me on LinkedIn. We're here to help. We love startups. And we enjoy working with startups. We do offer programs for startups where they can get in-house counsel at a significant discount, 60 to 70% in exchange for equity. So you can have someone on your side helping you with all of these things. And you know, so reach out to us. We're, you know, well, anybody here can reach out, and I'll give them a free consultation and help them out. So
And I just want
thank you.
I want to let everyone know there's a link in the chat if you want to jump on Alberto's calendar. It's right there. And if Alberto, if there's anything else, you feel free to post right there. But we're close to closing up here. It's been a great time wherever you are in the world. Could be evening, could be morning, but you know, hopefully you had an enjoyable time. And Alberto, last words here, man.
Nick, thank you, and thank you everybody for coming, and thank you, Luis, and I posted also in the chat. I put my LinkedIn. They're welcome to connect on LinkedIn. Go to the website, go to my calendar, sign up, and we'll have a conversation. Thank you all for coming, and once again, Nick, thank you very much for having me.
All right.